In this video, we will see who is a necessary party and who is a proper party in a suit. We will look at this special case, Mumbai International Airport Pvt Limited versus Regency Convention Center and Hotels Pvt Limited. Now, before we get into the case, let us look at who is a necessary party. Of course, by the word necessary, we mean that if the party is not there in the suit will necessarily fail. So, a necessary party is a person who ought to have been joined as a party and in whose absence no effective decree could have been passed by the court. So, a necessary party has to be in a suit. A proper party, though he is not a necessary party, is a person whose presence would enable the court to completely, effectively, and adequately adjudicate upon all matters in dispute in the suit, though he need not be a person in favor of or against whom the decree is to be made. So a proper party basically is a person whose presence is required to enable the court to completely, effectively, and adequately adjudicate upon all matters in the dispute. Though really he may not be a person in favor of or against whom the decree is made. Now, whenever a plaintiff files a suit in court, it's up to him to decide which parties he wants to seek relief against. So it's up to him to decide who he should implead in the suit. That is the general rule. Now, Order 1, Rule 10.2 of the CPC talks about impleadment of proper or necessary parties. It says that court may strike out or add parties. The court may at any stage of the proceedings either upon or without the application of either party and on such terms as it may consider just, order that the name of the party who has been improperly joined, either as plaintiff or defendant, be struck out, and that the name of the party who ought to have been joined, again as either plaintiff or defendant, then either who ought to have been joined, number one, or two, the presence before the court may be necessary in order to enable the court to effectually and completely adjudicate upon and settle all the questions involved in the suit. Then that person needs to be added. Now, look over here, it's important. Number one, the name of the person who ought to have been joined, or the name of the person whose presence before the court is necessary in order to enable the court to effectively arrive at the issue, to settle the questions involved in the suit. So in short, basically, the court is given a discretion to add as a party any person who is found to be necessary or proper party. Conversely, if a person is not found to be proper or necessary party, the court has no jurisdiction to implead him against the wishes of the plaintiff. Now we come to this matter, Airport Authority of it's Mumbai International Airport Pvt Limited versus the Airport Authority of India. Now, the Airport Authority of India was formed under the Airport Authority of India Act 1994. The objective of the Airport Authority of India was to develop, operationalize, and maintain airports in India. Now, in 2003, this Act of 1994 was amended, whereby the Airport Authority was allowed to lease the airport premises to private operators and assign its functions to its lessees. Most of the functions, except functions such as air traffic control, watch, and ward. Now, after this amendment, it was decided to modernize Mumbai International Airport. Therefore, the Airports Authority of India took out an information memorandum, asked for bids came in, and Mumbai International Airport Pvt Limited won this contract to modernize the Mumbai International Airport. So, on the 26th of April 2006, the lease deed was signed between Airport Authority of India and Mumbai International Airport Pvt Limited, wherein it was decided to Airport Authority would lease Mumbai Airport to Mumbai International Airport Pvt Limited on an as-is where-is basis for a period of 30 years. Now, let's look at the clause on the subject matter of this particular agreement, lease deed. It said that all land, along with any buildings, constructions, immovable assets, if any, which stood on that land, which is described, delineated, and shown in Schedule 1 hereto, other than number 1, any lands, along with any buildings, constructions, immovable assets, if any thereon, granted to any third party under any existing lease constituting the airport on the date hereof, and to any and all other carved out lands. Carved out lands, we will see what they are. So basically, the lease deed talked about all the lands which is described in Schedule 1, other than the lands in 1 and 2. That is, any land given to third party under lease and any other carved out assets. Let's look at Schedule 1 of the lease deed. Now, Schedule 1, instead of giving a detailed description of the demised property, referred to a map demarcating the demised properties annexed to the lease deed. The map annexed as Schedule 1 was the plan showing the demised premises, indicating carved out assets and lands invested with the Indian Air Force and the Navy. Now, what were these carved out assets? The carved out assets included a new ATC tower, the NAD staff colony of the Airport Authority of India, 3 land lease to the Hotel Leela venture, 4 retail fuel outlets outside the airport, its operational boundary, 5 convention center. Now, the map also contained a note. Now, this is very important. The map contained a note below the listed carved out assets. And what did this note read? It read that the parcel of land measuring 31,000 square meters is currently not made part of the lease deed. Again, the parcel of land measuring 31,000 square meters is currently not made part of the lease deed, but may become part of the demised premises subject to the court verdict. Now, of course, you know that this is enough to tell you that on this land parcel of 31,000 square meters, there would have been a court case. This brings us to the matter between Regency Convention Center and Hotels Limited versus Airport Authority of India and others. Now, this was a suit for specific performance filed by Regency Convention Center and Hotels Limited against Airport Authority and others. Now, What the Mumbai International Airport Authority said was this land at measuring 31,000 square meters was part of the airport. It was supposed to be handed over by the airport authority to Mumbai International Airport, but it could not because there was a court case going on. And this court case was suit number 6846 of 1999, filed in the Bombay High Court, and it was between Regency Convention Centre and Hotels Limited versus the Airport Authority of India. In this suit, the Bombay High Court passed an interim order. According to the order dated 2nd of May 2001, the order read as follows. The Learned Counsel for the Airport Authority of India stated that the land measuring 31,000 square meters, which would be separately demarcated, will not be alienated, sold, transferred, and no third party interest in that land would be created by the Airport Authority of India without seeking leave of the court. So, ineffectively, there was a stay on this land parcel of 31,000 square meters. And of course, should Airport Authority of India want to do something on that land, then they need to take permission of the court. So this interim order was acting as a stay on the development of that 31,000 square meters of land. Now, Mumbai International Airport Pvt Limited said that it wanted to be included as a party in this suit between Regency Convention Centre and Hotels Pvt Limited and Airport Authority of India. Now, what were the reasons given that it wanted to be impleaded? It said basically that it is a necessary and proper party, and therefore it must be impleaded in this particular suit between Regency and Airport Authority of India. How did they come to the conclusion? How did they put up an argument? How did Mumbai International Airport put up an argument that they were a necessary and proper party? According to them, Mumbai Airport is surrounded by developed land area with very limited opportunities to acquire any land. The site constraints limit the possibility of development, and therefore it was necessary to make optimum use of the existing land in the airport for the purpose of modernization and upgradation, and therefore the disputed land which was lying idle was required for modernization. This was Mumbai International Airport's argument for getting impleaded in the suit between Regency and Airport Authority of India. Mumbai International Airport contended that its interest was likely to be directly affected if any relief is granted to Regency in this suit. Mumbai International Airport further argued that in the information memorandum which Airport Authority of India had given out with respect to Mumbai International Airport while seeking bids to privatize the airport, this particular information memorandum did not exclude the area which was subject matter of the suit between Regency and Airport Authority of India, and that the suit plot could not, however, be leased to Mumbai International Airport because of this order of the Bombay High Court which was pending in this matter. Thus, Mumbai International Airport claimed that it was a necessary and proper party to be impleaded in the suit between Regency and Airport Authority of India. Basically, on the ground that it had or would have an interest in the suit land, and at all events it was interested in acquiring it by lease, depending upon the decision in the suit. Now, that was Mumbai International Airport's argument in court. before the single judge. What was the argument of Regency Convention Center and Hotels Limited? They said that Mumbai International Airport Private Limited was not the necessary or proper party in the suit. Why? Number one, they did not have any interest in the suit property. Two, Airport Authority of India itself held 26% stake in Mumbai International Airport. So basically Mumbai International Airport was protected since Airport Authority of India itself was defending the suit. What did the Airport Authority of India say? The Airport Authority of India also was against impleading Mumbai International Airport Private Limited as a party in the fight between Regency and Airport Authority of India, on two grounds. Number one, it would it would delay the recording of evidence and affect the interests of the Airport Authority of India. And second, most important, over here, Airport Authority of India said that the suit plot at measuring 31,000 square meters was not leased to Mumbai International Airport. Now, on the 1st of April 2008, the single judge of the Bombay High Court dismissed Mumbai International Airport's application. According to the single judge, Mumbai International Airport was rather yet to acquire any interest in the suit land. And as the pending suit by Regency against Airport Authority of India was a suit for specific performance, remember there were two suits. Number one, between Regency and Airport Authority of India, and between Mumbai International Airport and Airport Authority of India, as well as Regency. Now, in the suit between Mumbai International Airport and Airport Authority of India, Regency was not a party. In the suit between Regency and Airport Authority of India, Mumbai International Airport was not a party. So therefore, the single bench concluded that it could not permit impleadment of Mumbai International Airport with reference to some future right, which may accrue in future after the decision of the suit. So the single judge dismissed Mumbai International Airport's application. Of course, Mumbai International Airport went to the division bench. Now, the division bench order came in August 2008. The division bench held that Mumbai International Airport did not make out a case that it was a necessary party. It only claimed to be a proper party, and that too, its claim was not based on any present demise but on future expectation. And therefore, it too dismissed Mumbai International Airport's application to be impleaded as a party, necessary and proper party, in the suit between Regency and Airport Authority of India. Matter goes to the Supreme Court. So what is before the Supreme Court? The question before the Supreme Court was whether Mumbai International Airport is a necessary or proper party to the suit for specific performance filed by Regency Convention Center versus the Airport Authority and others. Here too, in the Supreme Court, Mumbai International Airport failed. The Supreme Court held that Mumbai Airport is neither a necessary party nor a proper party. It held that Mumbai International Airport Private Limited is neither a purchaser nor a lessee of the suit property, that is at 31,000 square meters land. It has no right, title and interest therein. Now, Regency Convention Center has not sought any relief from Mumbai International Airport, The presence of Mumbai International Airport is not necessary for passing an effective decree in the suit for specific performance, nor is its presence necessary to complete and effective adjudication of the matters in the issue in suit for specific performance filed by Regency. So the Supreme Court basically has held that Mumbai International Airport was neither a proper party nor a necessary party in the fight between Regency and Airport Authority of India. It said that a person who expects to get a lease from the defendant in a suit for specific performance in the event of the suit being dismissed cannot be said to be a person having any semblance of title in the property in dispute. Now, Mumbai International Airport had claimed to have some future right, and the Supreme Court said, sorry, you do not have a right. Now, the Mumbai International Airports Council further argued, and this was the second contention, that Section 12A of the Airport Authority of India Act stated that when Airport Authority of India granted a lease to the premises of an airport to carry out any of its functions enumerated in Section 12 of the said Act, the lessee who has been assigned any function of the Airport Authority of India shall have the powers of the Airport Authority of India necessary for the performance of such functions in the terms of the lease. And therefore, according to Mumbai International Airport Pvt. Limited, it should be deemed that it has stepped into the shoes of Airport Authority of India as far as the airport premises was concerned. Supreme Court bunked that contention. It said that the appellant as lessee may certainly have powers of the Airport Authority of India necessary for performance of the functions that have been assigned to them. Now, what exactly has been assigned? It is the function of operation, management and development agreement with reference to the area that has been demised. Obviously, the appellant as lessee of the airport cannot step into the shoes of Airport Authority of India for performance of any function with reference to an area which has not been demised or leased to it. The third contention of Mumbai International Airport in the Supreme Court was Mumbai is a busy airport, its traffic is increasing, there is a need to modernize every inch of the land. The suit land, that is that 31,000 square meters, was a part of the airport land, and because there was an injunction against it, it was not included in the lease. And therefore, Mumbai International Airport referred to the note which was made part of the lease, which said that 31,000 square foot was not made part of the lease, but may become part of the demised premises subject to the court verdict. Supreme Court held, sorry, this does not in any way help Mumbai International Airport claim a right to be impleaded. What the Supreme Court said was, if the interim order in the suit filed by Regency came in the way of granting the lease of the suit land, it is clear that the suit land was not leased to the appellant. Look at it the other way. If Airport Authority of India succeeded in the suit and the suit land was to be leased to the appellant, that is in itself is not sufficient to hold that the appellant has any right, interest or semblance of any right or interest in the suit property. The Supreme Court further went on to say that when Mumbai International Airport is neither claiming any right or remedy against Regency, and when Regency is not claiming any right again or remedy against Mumbai International Airport, in a suit for specific performance by Regency against Airport Authority of India, the Mumbai International Airport Pvt. Limited cannot be a party. So, the allegation that the land is crucial for premier airport or public interest is not relevant to this issue. And on this ground, the Supreme Court dismissed the appeal.